Excuse me? Asserting that we have rights is a breach of the peace? Come on, let's do it.
All right, everyone. We have our good friend Jane Scharf with us, and we're going to be reviewing, guys, a case on the ground happening right now. And part of the reason why I want to introduce this case is I myself am not up to date exactly on what's going on with this particular case. However, it's a case that's stemming from Quebec. So it's a person who lives in Canada. So this is very important to every Canadian. And we want to introduce this to show you also what some of the issues are, not only with the charter, but the effects that the charter has had on a lot of the civil servants. They're essentially actually starting to buy into this idea that they can just willy-nilly, if you will, override people's rights. And I think that this is another a great poster child case for trial by jury. That's very important. That's part of the reason why we want to introduce this case to you. Plus, it's a case that's on the ground happening in Canada. And that's important because you can know that this is not one of those, CBC, CNN fake news deals. It's a true testimony with people that are what's happening to people on the ground, and that's what this is about. And the person's name, her name is Bozena Liz, and Jane Scharf is very much up to date on this case. So Jane, if you don't mind, I know all my listeners already know who you are, sister from another mister. I'd like you to maybe give us a few details, if you will, on this Bozena Liz case, kind of introduce the frame of it.
Okay. I was there today when this incident with the mall police and the court and the police all went down, and I'll build to that. I'll go back to the beginning, which is a bylaw ticket for not wearing a mask in a mall.
Okay, so this is probably dating back around 20...
It was 2021.
2021, okay.
Yep. And she told them that she had an exemption.
Over there, the law was that if you stated that you had a mask exemption, you were exempt. That's exactly how the bylaw was, right? Okay, continue, please.
But they disregarded that, and they called the police. The police arrested her with cuffs, brought her down to the station, and physically forced a mask on her face.
Okay, so not only did they ignore her exemption that she stated, which essentially ignores their own bylaw, but then on top of it, without any cause, they force a muzzle over her face, quite frankly, once again, overriding her civil liberties without they just do it on a whim. And much like, right, that idea, well, we get to limit your rights however and whenever we feel like it, that's why we've been making the case that the charter is not only dangerous in a courtroom, but it's dangerous on the psychology of the civil servants themselves, because now they're starting to believe they can just override rights and even forcing masks on people. Please continue.
And further to that, we're trying to show you these details because it's evidence of exactly what happens when you don't have juries. Juries are there to make sure that the laws don't go to excess, and the process where a claim is being made, that the law does not operate in excess of rights and justice and so on.
Because they have power, and so the people have to make sure that they don't overstep that sphere of authority and over-abuse with the power that they have.
Exactly.
Because it's always the one with the power that can abuse it.
Exactly. So these juries are independent people, independent of the court, and their job is to look at the facts of the case, but also examine the law itself. So none of what I'm going to tell you would have occurred had there been a jury in place for the whole process. It would be all over with. It would have took maybe an hour of judicial review, and she would have been found not guilty. And very likely the jury would have overturned the mask law itself.
Because we got to remember, they don't have to convince all 12 that she's innocent. Yeah. They just need one person on that jury to say, well, wait a minute, this particular mandate says if she states that she's exempt, then she's exempt. And then clearly her civil liberties, you can't force things over people's faces.
But they can look at the law itself too. I mean, that would be a case where they're looking at the facts to determine if it should have been applied in this case, like in the case of murder, and then somebody's mentally ill or whatever. In this case, it would have been okay. There would be three different directions it might go. They might find her guilty, or they might find her not guilty because the law does not apply to her in this case, or they might find that the law itself was invalid, and not only in her case, but in all cases. And that's what I would argue for, because they're unconstitutional. Not charter. Unconstitutional. Yeah, because it's criminal law and it's being set by the province without the proper process, consultation, and all of that stuff that goes with it. Anyway, she got this ticket. She registered to challenge it, and right from the get-go, first time she walked into court, the judge, JP, I should say, made a ruling that no one could be in the court with her, not even a support person, because she asked that I could be there as a support. No, clear my courtroom. So that was the first indication that we weren't going to get very, reasonable treatment in the process.
And if you don't mind me expanding on this, again, our position is, and I think you're going to agree with this, as soon as you start seeing private, you can't see any of this, the public doesn't get to hear the two sides of the story, if you will, right there, that there's an issue. And if I don't, and you know how I love to, we've talked about this in scripture. How did they handle the case with Jesus? What did they do? They came at night, and they ran a kangaroo court, and they made all the decisions, but always undercover, under dark. So as soon as I hear a JP saying, clear the courtroom, no one else gets to hear this, I know there's a huge issue. And the likelihood of you getting a fair hearing is slim to none when a state-paid judge is saying nobody gets to be here. Well, please continue.
What she did, there was a number of other issues, but she primarily, they're challenging the bylaw itself. And then we don't get to do it through a jury. It has to be done through a judge in that setup. And also, we challenged her ruling about closing the courtroom, because she said from here on, no one will be allowed in the courtroom. So, but she made one exception, because Bozana had said she wants me to be her Mackenzie friend, which there's case law that says that any accused can have somebody there to assist them. And she said, however, that person will have to sit way over there in the corner away from you, and she can take notes for you, and that's it. She can't interact with you. She can't, help you with your paperwork that you're presenting, nothing.
And this, by the way, this goes back to that idea that we've been learning, how originally trial by jury, the quote-unquote judge really wasn't a judge. They were a convener, more like a moderator, and they weren't allowed to instruct the jury in any shape, way, or form. And this is the issue when a judge says, okay, we'll let you have it, but once again, we're going to restrain and or restrict even that right, because we're going to make that person go to the back. They won't be able to say anything. You won't feel as comforted, clearly. You won't be able to have like a moment of conversation because Jane's all the way in the back, and all she can do is take notes. So once again, even in the courtroom, your rights are being limited because you've got a state-paid judge that can just willy-nilly say and do whatever they want. Please continue.
And the thing is, we have a right to an open trial. That's in the Bill of Rights very clearly. And it's supposed to be open, fair, and it's supposed to be conducted by an independent, impartial tribunal, which means it has to be not anybody that works for the government, because these are government policies. So you can't have a provincial judge who's appointed, well, she's a JP, so provincial JP that's paid by the province adjudicate whether the province is overstepping. That is the classic conflict of interest. And we are seeing the effects. We are seeing the very reason why conflict of interest has been something that's been prohibited and has been, articulated and we strive for that. So
and that's why in Section 2E and F, in combination in the Canadian Bill of Rights, it's made very clear, as we've said many, many times, royal assent, federal statute, all individuals have a right to a fair hearing with an impartial situation, right? So, and clearly this is conflict of interest. and independent.
And impartial. Yes.
Independent and impartial. And that's stated very clearly in the Canadian Bill of Rights. Clearly not in the Charter, but clearly in the Canadian Bill of Rights. And that's another reason why we keep pointing to the bill that has royal assent and it's a federal statute and applies to every individual. And we see now those words individual in the Section 1 of the Canadian Bill of Rights. Please continue.
Yes. So they made a constitutional question regarding the constitutionality of the bylaw itself, the mass bylaw itself. And the Attorney General of Quebec does a motion to dismiss that question and presents 450 pages in French. And some of the case law is not even available in English anywhere. And too bad, so sad, we're doing it. Completely disregarding the rights of the defendant trying to defend themselves in a foreign language, in a whatever language. So I shouldn't get into all the details, but I will say that there was maybe 10 egregious things that JP did throughout the early proceedings. And then ultimately she agreed to throw it out. I don't think any of it was valid or reasonable, but regardless, they went on to appeal it. They've sent an appeal in on that decision to throw out the constitutional question. And they put in another constitutional question and also a request for jury. So the constitutional question, the second one, has to do with the jurisdiction of the court. Just 1 second, my dog is going off.
It's at 6:13.
Sorry. Okay. So the second question is the jurisdiction of the court. And what the issue there is, it's a statute court, which is not constitutional. And the Constitution sets up the structure of the court, which is federal regulation and federal appointment of judges. But this one is a provincial regulated with provincially appointed judges. So that's unconstitutional in their argument. And as well, they put in a request for a jury.
I mean, when you say in their argument, you're talking about basically our side, if you will, right? Bozena's side, right? Yes. Because she's got a couple people working with her.
They did ask that court to clarify if they had jurisdiction to hear their rights. Like, that's what the worry is, right? That this illegitimate court doesn't have any authority other than what its statutes give it. And their statutes don't indicate that they can adjudicate regarding your rights. Okay. That the normal court, the properly constituted court, constitutionally valid court, has what they call inherent jurisdiction under common law. So it doesn't have to be spelled out anywhere. It's what has evolved over the years through common law. And they have fully the authority to deal with the Bill of Rights, and they have, there's thousands of cases with Bill of Rights where the court fully took their judicial authority to deal with it. So
what you're suggesting is this court doesn't have that.
Doesn't have that, and they would not even answer it properly. They just said unfounded question and just threw it out. Didn't even let it get heard. You know what I mean? Like, they made the application, and the judge in handwriting writes on it. Like, she strokes off their requests one after another and says unfounded, 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 and there, throws it away. So then they're coming today. This was supposed to be their first day of trial, and they obviously have serious questions that haven't yet been answered. And basically the worst thing is the jurisdiction of the court to even hear it in the first place. So I got there.
Yeah, because if you're going to a court that doesn't even have the jurisdiction to hear it, on many levels, you're essentially wasting your time, aren't we?
Yep.
Okay,
so
continue.
I get there, and I have a service dog, and I have a card for the service dog. Right? I don't know. Is that, that show there? Okay, there it is.
Okay. So that's a legitimate, if you will, legal service dog card. You get to have a service dog with you.
Yeah, and on the back of it is written the federal law that gives me a right to enter any public place, or any place the public goes. It doesn't even have to be just a public place. It could be like a mall or whatever. But in this case, it was the court. So it's like totally public. And I walk in and they come up and they say, "Do you have a card?" And I show them a card. And they have this list of acceptable agencies that issue cards. And the agency that issued my card wasn't on their list. So she said the security said that I can't come in. So I'm supposed to be there as her Mackenzie friend, which was allowed by the court. And so I just went in the elevator and went upstairs. They came in the elevator and got me and physically pushed me in the elevator and then pushed me off the elevator on the main floor and absolutely disallowed. We talked to the director as well, and there was no acknowledgement. He made this list up, and my friend V said, "Where do you get the authority to limit the access?" The actual wording of the legislation that I'm resting on says, "No person, directly or indirectly, alone or with another, by himself or herself, or by the interposition of another, shall deny to any person the accommodation, services, or facilities available in any place to which the public is customarily admitted, discriminate against any person with respect to the accommodation, service, or facilities available in any place to which the public is customarily admitted, or the charge for the use of them, for the reason that the person is disabled person accompanied by a service dog or a certified dog trainer." So that's federal law, and that's also supported by the Canadian Bill of Rights, Section 1.
So once again, we have a situation where we have people in civil servant positions that just go, "No, we can limit that anytime we want." And that's what we've been arguing for a long time, that it's soaked into the mentality and the psychology, but that they could just, well, yeah, we know you have that right, but we get to override it however and whenever we feel like it. And we get to, well, then ultimately then you're actually saying that you get to override federal statutes and federal laws just because you feel like it, which is not true, which is not lawful, nor is it legal. So now your rights have been essentially offended, if you will, or, they're attacking them, if we want to use that terminology. But however we word it, they're obviously ignoring your true rights to having a service dog with you. And then in the process, they're injuring, if you will, the person who's essentially the case is about Bozena Liz, who wants her Mackenzie friend there and has a legal right to the Mackenzie friend. So more rights being completely violated because of this ignorance.
I've used this card for 10 years, and I've never been refused access. I've had access hundreds of times to the Ontario or to the Ottawa court, and I had access to Gatineau Municipal Court about 2 weeks ago without a hesitation with the card. So this director of this courthouse just pulled it out of his ass, made his own list up, and I'm only letting animals in. And actually, the Canadian Institute for the Blind certification is not even on his list.
Wow.
They do intense training, that agency. Like it costs something like, I don't know, it's like $50,000 or something to train the dog for the blind, CNIB, and they do certification and whatever. It's not even on the list. There's I think there's two Quebec agencies, and then I think they have like 5 federal ones. So I think it looks like what they've done is they've eliminated anyone that's not federal, and the federal ones aren't even federal anyway. Like they just say Canada in them. Like it's just service that's available Canada wide. It's not like federal government or something.
But again, like you said, they just made up the list because they just made up a list. And once again, that's not a lawful proceeding. No. That's not an appropriate way to handle law. And it's sinking into the mentality of these folks who have decided they get to make whatever decisions they want without having it authenticated or any kind of due process whatsoever. And then in that process, they're essentially coming against people's civil liberties. And that's why we're saying this is very, very important. And it's very important for everybody to start, educating educating the civil servants on the ground and letting them know that they can't just willy-nilly override people's civil liberties, right? That's why the NOLs are out there. That's why we're talking about the small claims court. That's why we're talking about appeals. That's why we're talking about having the conversation, exposing these cases too, because for, many of you might end up having a situation where you have a service dog or someone that you care about has a service dog, or in a situation where you're in a courtroom and you want a Mackenzie friend and it's your lawful right to have one, and then some, state paid person has decided, we've decided you don't get that, even though, it is your right. We're just going to go ahead and remove it. So this is what we're talking about, to expose this kind of behavior. All right, please continue.
So several people were helping me to try to deal with this, but we didn't get anywhere. And then Bozana was going to request from the judge to let me in because I'd already been recognized as Mackenzie friend. So she goes up. I should say not the judge, the JP. Her name is Auger, by the way, Christine Auger, Auger. Anyways, we went upstairs, or she went upstairs rather, with Liliana and a few other supporters. And they got to the door of the court, and the court held out a plastic bag and told everybody to put their phone in the bag. And Bozana said, no, my phone is off, but you're not taking my phone. You have no authority to take my phone. So she's arguing with them. So they arrested her.
Because she wouldn't give them her property.
Yeah. So
we, of course, have enjoyment of property in the Canadian Bill of Rights, right? Yes. And yet they just said, well, too bad for you.
Yeah.
Okay,
so then they arrested her, dragged her off to a cell they have conveniently located in the
So they
building.
Arrested her. I just want to make sure I'm clear on this because, go ahead.
Mall cops. These are mall cops. They're security. It's not police. And they're physically manhandling her and arresting her and putting her in a cell and wouldn't let her have, she wanted to call me, right? Because I'm a licensed paralegal. No, you can only call the ones on our list here. Here's the list. So that she didn't do that. And then they took
And this is all because she wouldn't give them her property.
Her phone, yeah.
Right. And she was certainly saying, I'll shut it off, but I'm not going to give you my property.
Yeah, exactly.
Okay.
So then then they confiscate. She actually had two phones. She has a backup phone. And I should say also, this was quite dramatic to take her phone because her mother is very ill. She's going to Poland on Sunday because her mother's not expected to live. So that's cut off communication by removing that phone. So
because Bozana herself is around the 60 years of age, by the way, she probably let everybody know that this is not, some 19-year-old that's out to, whatever, full of pee-pee and vinegar. This is a 60-year-old fellow Canadian.
Yeah. Retired civil
S.
servant, actually, federal civil servant.
So say that one more time. Say the last part one more time.
Retired federal civil servant.
She's a retired federal civil servant. Wow.
Yes. Yeah.
Well, and that's a good lesson to all of you out there who might be thinking that, you're part of the civil servantry, that they'll be friendly to you. Well, careful now. Yeah. Careful who you're dancing with.
The next part of this is really bad. They kept her in that cell for about, I didn't record it exactly, but at least 2 hours, but it might have been more than 2 hours. And when they released her, they kept her phones and told her, we have confiscated your phones, period, end of conversation. And they gave her a bunch of paperwork. Oh, yes. And she was charged for obstructing the mall police.
Sorry.
I know. Like the mall
absolutely
cops. Like literally, the movie Mall Cops?
Mall Cops.
That's what they are, mall cops. Cop wannabes. Okay? All dressed up and,
And did you say they confiscated both phones?
Yes.
So they didn't even let her have one out of the goodness of their not so good hearts. Okay. All right.
Yeah.
And this is hugely an issue.
Yeah. And so while she was in the cell, we were calling the 911 because we were very disturbed by this, arbitrary detention of this person who didn't do anything. There's like 5 people that can confirm she wasn't threatening. She wasn't doing anything other than refusing to give them her phone. So V called 911 and they just blew him off. They're not going to respond. So I called Okay. And they told me, I'm going to hang up now. And if you call back again, I'll send the police there to give you a ticket. And I said, well, you might as well give me the ticket now, because I will call back again if you hang up. She said, okay, fine, I'll send the police. So the police came and gave me a $280 ticket because we called 911 because our friend was locked up arbitrarily in a cell because she wouldn't give them her cell phone while she was trying to deal with being forced to wear a mask when she's medically exempt. This is how bizarre these people are, and had no, they think they're doing the right thing or something. No, they were all on it. And some of them were enjoying it. You could see some of them were like, ooh, we don't like this. But others you could see they were like, yay, we get to bash people around. Woohoo, see how powerful we are because our director told us we can do this. Well, they're all going to get tuned. Every last damn one of them. They're going to be sued for one thing, especially the director of the court. He's getting it. So this was and we're saying that this is the poster child for the need for the jury. The whole thing, to protect us against arbitrary laws, because the masking laws are arbitrary laws to begin with that don't comply with common law respect to informed consent, because a mask is medical treatment. So forced masking, and then of course there's all the, if they don't, it says on the box it doesn't help spread virus, and yet
not to mention the fact that, quite frankly, this is a breathing apparatus here, and
it's harmful. Bacteria, and you're ingesting carbon dioxide.
We've been around long enough
too. With children, if your teacher has that on, or somebody with hearing problems, that's going to impede them from lip reading, etc., and so on and so on,
etc. Yeah, but bottom line is we need that. Bottom line is we need that trial by jury so that person gets to have a fair case, a fair hearing, and let's let the people decide whether this was an appropriate bylaw or mandate to begin with.
Exactly.
Right? But if they can just arbitrarily just do these things like this, they're using power and intimidation, which is clearly a mark of totalitarianism. That's not how our country operates.
Exactly. And then they're abusing their authority to maintain this. So they overreach, and then they use their authority to maintain or try to establish the normality and the legitimacy of it. And that is the very precise reason why the barons that demanded that the king acknowledge their articles in the Magna Carta, that's why they put that in as their central feature, that all claims made against someone would have a jury. And that was what they believed would keep things, equal, or not equal, but it would keep the state from overstepping. And I believe that it will. It does. And
it's certainly going to be better. It's certainly going to be better than a deck that's already stacked with a state-paid JP or a state-paid person adjudicating over a situation where the state has done something and the civilian or the person on the ground says, well, that ain't cool. So clearly a trial by jury, you're going to have 12 members of your peers, if you will, and out of the 12, there might be 1, 2, or 5, or 7 that might start asking some good questions about what the situation is. You're not going to get that from a state-paid judge. They're not going to be independent. They're not going to be impartial, and that's why the mechanism of trial by jury is so important, and that's why Mr. Diefenbaker put it into the Bill of Rights, and that's why they don't want you to use the Bill of Rights, and they don't want you to show that light and the mechanism of trial by jury. Go ahead.
They, as in the individuals and attached to the UN body, that they want to establish a communist country, and first and foremost thing that they have to do to bring that about is eliminate your rights,
individual civil liberties,
and the court serve them and their power and their interest and the power and interest. And don't forget, they want to destroy business as well, right? They want to take all the power from business, all the power from churches. They always do that every time. Like all the history of any country that was taken over, they attack the church, and they attack the businesses, and they attack civil liberties. Those are the 3 key cornerstones of a communist country. And that's what they're not there yet, but that's what they're working on. They're like bashing away at our rights and our protections and our infiltrating our system and normalizing, making people like these meatheads that dealt with Bozana today, make them think that they're doing something important in violating your rights. Important for who and for what? Certainly not for this country or anybody in it.
That's right. And that's why we've been saying from the beginning, really from 2020 for sure, is that, listen, once again, when you start hearing them talk about, your rights aren't as important as something else, you can be sure that as soon as they're saying that someone's trying to make a move or some group is trying to make a move so that they can assert even more authority. And so, because we've said this before, it's one way or the other. Either the people have the authority, and in legitimacy, that's always the power, or it's going to be them, and not because they can lawfully do it, but if they can convince you to essentially give up those civil liberties, then they'll just have it by default. And that's why we're saying, listen, you need to empower yourself individually, right, and make sure that we start educating people from the bottom up. And yes, you might have some trials and tribulations on that, but it's going to be worth it, because the opposite of that, and I've said this many times, you're not going to be prepared to take this battle on if you've lost them, right? Right now, you still have them. Right? You definitely have them. If you get to the point, right? In other words, the further down the road they kick this ball, right? Think of it like football, right? The closer they get to their goal, the worse it is for you. So we want to push this ball all the way back towards their end zone, so that we get them back, and we make sure that we remind them that the power actually is with the people. That's the lawful and proper way. That's, was stated clearly in the Magna Carta, and it does stem from that time frame. And, because we have to because we're giving this level of governance, if you will, we're asking them to govern, we're putting them in a power authority. We just clearly we have to maintain the control of it. Otherwise, they'll start to abuse it. And that's the whole idea of the trial by jury, to make sure that those who we do elect to represent us don't really represent us in its fullness. We ask them to conduct, and then if there's an issue, the people say, nope, that's not cool, or yeah, no, that was okay. And you keep those people in check, right? That's the idea with trial by jury.
And these guys have already made a request for a jury, and they want to have the jury deal with their constitutional questions, because they have two. One is the constitutionality of the bylaw itself, the mass bylaw, and then the jurisdiction of the court. Basically, they're claiming that it's an unconstitutional court. So those are their two questions. We want jury to deal with those, and we want a jury to deal with the underlying charge itself, so the charge can be nullified.
So then where does this go next? Because clearly this courtroom doesn't even have the jurisdiction to be able to say yay or nay to any of this.
They're not back there at all. They're not there at all. They have an appeal of the decision to throw out their constitutional question. They've got an appeal coming up. I think it's on October or something. I can't remember the date. They've, like I say, they've already got a request in for jury. So we're going to make affidavits. Each one of us that was there today, there was 9 of us there today. So we'll all make affidavits in support of their need for the jury. And we're even going to ask other people like Mitchell Albert in New Brunswick, who had a similar problem with the court. He wasn't wearing a mask, and he was trying to go to court, and they were telling him, no, you can't go to the court without a mask. And then they charged him with contempt, and he sued the judge because the contempt charges were thrown out because total nonsense. So he was suing the judge because the judge was acting outside of his authority doing that. He had no legal, right to do that. And he went to small claims court, and he had made a very good presentation with case law and all this, and they threw it out without any proper legal basis. They just threw it out, and he appealed it, and he put more work into it, more case law, and they're very brilliant down there. There's There's at least 3 of them that I know. I think there's a bigger group than that, but they're all very legal savvy, and they do deep dive into their common law case history and their case law. Anyways, it was thrown out. So again, his case can be documented in an affidavit and submitted as evidence. This is what happens when you go through a process that doesn't have a jury. That's
and where are you going to submit this?
It'll be submitted to the Superior Court of Quebec, because that's where their appeal is there. So they're asking that court, because their foot's in that door, they're asking that court to allow them to have a jury to hear the constitutional questions and to hear their appeal, and then the question, and then the other question. One question hasn't been heard yet. They don't want to. I think that's what all the hostility is about, because we're challenging their authority. Like, how dare we? So they're going to show us how much they have.
Right. Well, which again is actually, when I see this kind of behavior, that convinces me that you have none. Yeah. That convinces me because of the approach that you have. It's that kind of vile behavior, right, that convinces me you actually don't have the power. So that's why you're going into what I would call fear. Yeah. It's these fear tactics. Yeah. Fear, right? I could see the fear motivation behind it to try to kind of dismantle your position, your belief.
Your belief that you have rights.
And your trust in the system. And your trust in the system, right? To get you to believe, see, it's all corrupt, and get you to fall down, right?
Yeah. And I was arguing with the police officer at the end, like her rights and right to property, la, 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 la. And he said, "You watch yourself, or I'm going to charge you for breach of peace." And I'm like, excuse me? Asserting that we have rights is a breach of the peace? Come on, let's do it. And then he's like, oh, well, I didn't say that. And he backed off. How friggin' ridiculous. That was the verbiage. I wasn't threatening anybody. I was saying her right to property and, her liberty, having her off in a cell, and she has a right to protection from unreasonable search and seizure. So the very initial demand that you give me that cell phone that subsequently led to a forcible taking of that phone, that's a violation of it amounts to unreasonable search and seizure. And that's what I was arguing with the guy. And he's like, that's breach of the peace. He's threatening me. You watch yourself. That's breach of the peace. I said, well, let's go for it. He's kind of backed away.
It's breach of peace to cite the Canadian Bill of Rights. I guess really. Yeah, okay. Exactly. It's a breach of peace to recite a federal statute of the nation that was signed by all 10 provinces and received royal assent. Wow.
Yeah, that was based on 800 years of case law in the first place. Like John Diefenbaker says, he did his best to capture the rights that had been established through common law.
Right, and that's why he says, including, go ahead, please.
Including the Declaration of Human Rights and Freedoms from 1948. He mentions that also. He's trying to capture, because it says inalienable rights in there, rights and freedoms. Right. That one. And many of the other declarations after had a similar clause to what the Charter does, the limitation clause. But that one didn't have a limitation clause, that old one, 1948. That was right after all of Hitler's conundrum. And I think, I forget how many, it's like 162 countries signed on to that.
Wow. Okay. So again, and it cites that in the bill that that the bill is recognizing, not giving, recognizing that these rights were God-given, essentially. We're paraphrasing, but not the word recognizing. It's recognizing means that, that the bill is not saying that we're giving you the rights, we're recognizing that you already have them. And that's a huge statement in and of itself.
And protecting,
which clearly did not happen today.
Somebody said today, were they sleeping during the part of their oath that they're supposed to serve and protect?
Right. That's absolutely, and I have to say, this is the kind of stuff. These are the kinds of things we're going to have to say at the dinner tables. Even if some of your relatives might be participating in some of these operations, you have to let them know and remind them that they don't work for some kind of ghostly Eiffel Tower somewhere. They work for the people, and of course honorably and respectfully in both ways. But as I've been saying a lot lately, I say, look, it's the scriptures, for example, say honor to whom honor is due. And if the honor's not due, then that's a different situation. And I can honestly tell you that I will thank you for a good job, but I will not thank you for a bad job. And it sounds to me like Bozana, a fellow Canadian, did not get her fair hearing. She didn't get treated properly, and on top of it, her being 60 years-ish of age and female, that kind of breaks my heart on many levels. However, I like the fact that she's clearly got a lot of feist in her, and she's not giving up, and I'm glad that she has you, and I just thank you for kind of getting me up to date on this case, because I didn't know much about it. So I thank you, Jane, for sharing all this. And what if you don't mind, because we definitely want to leave people on that kind of, listen, we're still going to keep rolling, but this is part of the process. Kind of like I like to cite sometimes the Shawshank Redemption. Sometimes you got to go through that tube, that 500 meters of garbage and awful stuff to get on the other side, where you're finally all washed up in a suit and you end up with all kinds of money in Mexico. So the word picture there is sometimes you got to go through a lot of crap to get to the good stuff. So what's the final positive message, if you will, on this one?
Well, Rebecca put out a statement, and she did a live asking people to call the court and to call the police and register your outrage about the treatment. And we still would like to see more people called. Many people did. We got a lot of feedback from. She had a big show of support from the Stand for the network. So you can see that on Stand for the Facebook page, and it's on my page also, Jane Scharf, if you can't find the one on Stand for the.
Okay, so Stand for the Facebook and Jane Scharf Facebook, and of course Scharf is SCHARF. Continue, please.
Yes,
go ahead.
That's it. So they can call and express their concern. Also, you can see the videos on there. There's videos that are explaining what's happening. And V is going to make more or less a documentary of everything, because they have video of what happened to me with the dog, and then there's video of what happened to Hosanna, and also video of the different interactions that we had with the mall police, and then the police and the director, like earlier on. And when that goes up, I think there's going to be some feedback on or whatever kickback, on that through various people in their system. They're out of control, and they need to be tuned.
And so we just want to encourage everybody that they're just not going to roll over. And, so we're going to have to this is a 15-round fight. Okay. So, so even, and every once in a while, they're going to throw us a right hook, and every once in a while, they're going to throw us a left hook. But we got to just keep staying in the ring and keep fighting, because we have to believe that ultimately, right, that the good. And I believe Mr. Diefenbaker said this, that you send me a recording of him speaking, and he said, ultimately, the good always has to overcome the evil. It has to be that way.
It does. It always has, and it always will.
Let's follow that kind of message. That's a great way to end on this interview, Jane. Thank you so much. I know you got a meeting pretty soon, so thank you again for taking the time for filling us in on this one. Keep up the great work. Keep us posted, and we'll talk to you soon, sister. And of course, end up with your famous line.
Brother from another mother? No.
and
hashtag we got
this.